The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 3rd of February, 2016, are currently trading with gold at $1,138.10 an ounce, silver $14.63 an ounce, Texas crude $29.88 a barrel, and Bitcoin is currently sitting at about 370 U.S. currency. Today in history, the year 1966, the Luna 9 Russian spacecraft became the first unmanned probe to achieve a soft landing on the moon, or any other planetary body for that matter. Also known as the YE-6, number 13, it was the first probe to transmit photographic data to Earth from the lunar surface. In recent news, Sandra Merritt, one of the two indicted with tampering with governmental documents in order to create fake driver's license in a plot with anti-abortion activists to obtain the undercover video footage exposing Planned Parenthood for selling human body parts, turned herself into Texas authorities today. She posted her $2,000 bond and was later released. However, the news conference that she was scheduled to hold afterwards was canceled. David Daleiden, the main activist behind the videos, plans to turn himself over to authorities tomorrow, as attorneys have stated. He does ironically face an additional misdemeanor charge related to the purchase of human tissue. Ironic because, if you recall, a grand jury in Houston, Texas, that had been tasked with looking into the wrongdoing by Planned Parenthood announced that it was indicting Daleiden and Merritt instead. The results for the Iowa caucus are as follows. For the Republican Party, Ted Cruz, 8 delegates, or 27.7%. Donald Trump, 7 delegates, or 24.3%. Mark Rubio, 7 delegates, 23.1%. Ben Carson, 3 delegates, or 9.3%. Rand Paul, 1 delegate, 8,481 votes, 4.1%. Officially, Rand Paul did drop out this morning, stating the lack of funds and support as his main cause. Jeb Bush, 1 delegate at 2.8%. Carly Fiorina, 1 delegate at 1.9%. And John Kasich, 1 delegate at 1.9%. For the Democrats, it was actually decided by a coin toss which gave Hillary 6 wins out of 6 tosses. Hillary Clinton got 23 delegates and Bernie Sanders 21 delegates. This has been your lowdown for February 3rd, 2016.
Received my remedy today. Came in a box, just like they say. I accepted it for value right away. If not sooner, not later. We are originating.
Okay, we are back. Randy Kelton, Real Radio, and we're talking to Chris in Pennsylvania. Okay, Chris, where were we? You had one more question.
Well, I had a question about Wachovia just being, you know, the original lender and having MERS act as their nominee, making the assignment to Wells Fargo when Wells Fargo is clearly stating that Fannie Mae is the lender.
Okay, question. That brings up some issues. You just said Wachovia still exists as an entity. Who actually was the original lender? Was it Wachovia Bank N.A.? Wachovia Home Mortgage?
Well,
what was the actual lender?
Wachovia Mortgage Corporation was the originator of the loan. And we have...
Does Wachovia Mortgage Lender still have a corporate presence?
No.
Then Wachovia Bank N.A. is not Wachovia Mortgage Lenders. Wachovia Mortgage Lenders doesn't exist.
Right.
We have case law on that. We have got a really good treatment of that out of Austin by a magistrate judge named Austin.
Huh.
And he addresses Chase Bank N.A. and Chase Home Mortgage. And he said that while Chase Bank N.A. Home Mortgage is a wholly owned subsidiary of Chase Bank N.A., Chase Bank Home Mortgage is not Chase Bank N.A. So there had to be an assignment between the two. That's what this issue was about. So right. if Wachovia Home Mortgage doesn't have a corporate presence, then it doesn't exist.
Right, that's what I thought, because I always thought that the federal entity of these subsidiary banks who could work at state level don't work under federal law because they're state subsidiaries. Is that correct?
Wait, because they're I missed part. I'm having a little trouble understanding. You don't work under federal law because
they're not the Wachovia Bank N.A. would be the corporate. They work under federal law as the main bank, and all of their subsidiaries.
But Wachovia Mortgage, Wachovia Home Mortgage would almost certainly be filed with the federal government as a federal lender, but not necessarily. If they weren't, then yes, you could take them in the state.
Right.
Just because they're a wholly owned subsidiary, they are a completely separate company.
Okay. So I thought they were subsidiaries based on the fact that one governs federal law and the other subsidiaries are why the bank chooses them, because they don't act under federal law, they act under state law provisions.
In that case, you could certainly keep it in the state. But in your case, you don't necessarily want to keep it in the state.
Right. My point with that is that once the federal governing body, the corporation, folds, the subsidiaries lose their ability to act as a bank within themselves because they were merely subsidiaries of the corporation.
Not necessarily. If the subsidiary is a lending institution, it is most likely filed in its own right.
Okay.
Because as far as I know, they don't come under an umbrella.
Okay. Right.
I don't see how you would get very far with that argument anyway.
Well, in our pleadings,
the real argument is they don't exist.
Right. Well, in our pleadings, we made it apparent because while we were doing our homeowner's mortgage, homeowner's insurance, was stating that we went through some servicing changes throughout the career of this loan, and one of the servicing changes was from Wachovia Mortgage Corporation to Wachovia Mortgage FSB. And in that servicing letter, at the very bottom in fine print, it states that Wachovia Mortgage Corporation, as of this date, has become Wachovia Mortgage FSB, no longer exists. So everything...
Okay, now, did it say that it merged with the other company?
Did not say it merged. It said it changed its name, will be changing its name to Wachovia Mortgage FSB. And that...
Well, that doesn't require an assignment.
Right. Now,
because they're still the same company.
Right, but it no longer can do business as Wachovia Mortgage Corporation.
No. But it can do the business that existed. So,
okay. But only
because they changed their name, and this is a problem I ran into before in trying to find who actually had standing, because we had a company that I looked up and couldn't find it. It didn't exist. But then it had merged with another company. And now it was doing business under this other company name, so I couldn't find it. But the other company still held the mortgage that was in the previous company's name.
Okay.
Does that make sense?
It does, but what it doesn't make sense to me is if they changed their name to Wachovia Mortgage FSB and we received our payments went to them as servicer. Now, if they changed their name to Wachovia Mortgage FSB, wouldn't the name of the bank making the assignment be Wachovia Mortgage FSB if that came 5 years later? Wachovia Mortgage Corporation couldn't be the bank making the assignment.
I think it could. It is, because it is the same company. It's just doing business under another name. Reasonably, if, let's say, a woman inherits a house and the house is in her name, and then she gets married and changes her name, she still has the same rights to the house. And she could still transfer the house in her maiden name.
Okay.
Although I'm just guessing, because this is not something that's directly in my expertise.
Right.
It's a little too fine a question of law for me to be able to answer definitively.
Right. Since my wife had, changed her name and everything is registered in her, not in her, even though it was registered in her maiden name, she is now referred to as her married name and can only do business under that name. She can't do business as her former self. I would imagine that was the way it worked for everything.
Well, as to the property that was in the former name, she still has the right to act on that property. Now, the former name owner is the only one who can transfer. She could transfer the property in her former name, even though she's operating under a new name.
Okay.
Otherwise, it would be unreasonable.
Okay.
And generally, if something sounds reasonable, if it seems as though the law should work in a certain way to be equitable, it probably does. It's just a matter of figuring out how it does.
Right.
But it's certainly something that bears a little legal research.
Okay. So
okay, I really need to move along. We've got 3 more callers, and we've been over an hour. Do you have anything else that we need to handle?
Give me the federal title for the bankruptcy code that you're aware of. That
I think it's 11 U.S.C. 256, if I remember right. It's in the 250 area.
That's what I've been looking at. Okay, I just wanted to make sure I was in the right direction.
Okay, thank you, Chris.
Thank you, Andy.
Okay, now we're going to go to Scott in Texas. Hello, Scott. What do you have for us today?
Well, I'll just give everybody a little brief update on the charge that I filed against the judge, a criminal indictment with the Tarrant County Grand Jury. It came back no billed. So now I'll go ahead and submit it to the Dallas County Grand Jury since he was in Dallas County.
Okay, hold on. Do you have that letter you received?
I do.
Will you read it? This is a letter from the foreman of the grand jury.
Yeah, it's a pretty short letter. So let me grab it real quick. I didn't realize you wanted me to read it. So hang on.
Okay, while you're getting that, this is where Scott went before a municipal judge in a traffic issue and had filed Eddie's pleadings in the case and initiated a statement in his behalf in a motion here. And when he mentioned travel, the judge erupted and told him to not say anything else. He wasn't going to bring that in his court. So the complaint that was filed was based on the judge denying him due process. So he filed it. It occurred in Addison, Texas, which is in Dallas County. He filed it with the Tarrant County Grand Jury. Because I had worked with the new district attorney and kind of got the door open so you could take criminal complaints to them.
Okay, I got it right here. It's
Okay, hold on. He gave this to the bailiff, who gave it to the foreman, and this is the letter he got back from the foreman.
All right. We, the undersigned 4 persons, have both reviewed the materials you have sent the Tarrant County Grand Juries. As servants of the citizens of Tarrant County, we give all the correspondence and complainants sent to us our utmost attention. The Texas Code of Criminal Procedure, Article 20.09 states that the grand jury shall inquire into all offenses liable to indictment of which any member may have knowledge or of which they shall be informed by the attorney representing the state or any credible person. Upon consideration of your materials, we do not find a Tarrant County offense liable to the indictment under the Texas Penal Code. Further inquiry into matters beyond the scope of Tarrant County would not be a judicious use of the trust placed into us by the citizens of the county and be a waste of the grand jury's limited resources. This is not a determination on the merits. We encourage you to take your complaint to more appropriate venues such as the county in which your alleged offenses occurred. In addition to complaint.
Okay, hang on. About to go to break. Randy Kelton, Real Law Radio. We'll be right back. Now.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you. Until Satan get behind you.
Okay, we are back. Randy Kelton, Real Law Radio. And I'm talking to Scott in Texas. And the reason I wanted Scott to read that was so you would hear that part about no Tarrant County offenses. My question to the grand jury is, what part of all offenses subject to indictment is hard for you to understand? The Texas Code of Criminal Procedure does not say all offenses subject to indictment within your venue. It says all offenses. While a district judge who impanels a grand jury has a venue restriction, there is no such restriction on the grand jury. So, instead of going to the Dallas County grand jury just yet, or you can in conjunction, the next thing I would do is go back to the Tarrant County grand jury with criminal charges against the grand jury foreman. And I noticed that the document read grand jury foremans. Didn't it indicate 2 foremans?
Yeah, it was kind of weird. I mean, I don't know why it was plural like that, but
I take it was signed by one.
Well, it says the undersigned 4 persons.
Okay, so there's only one signature on it. So file a criminal complaint against that grand juror for obstruction of justice and official oppression. You can file that with the Tarrant County grand jury, and I'll help you put together the legal brief. I already have it on the subject. For one, I'll be filing myself.
Okay. And then, is this something that we need to really start pushing towards the Texas Rangers so that these guys will, we need to get these guys in.
Yes. Okay, here's the deal with the Texas Rangers. I talked to my local ranger, and I told him I was going to bring him complaints in. And he said he couldn't take them. He could only get complaints if they were referred to him by the district attorney. I told him that I thought that was very, very interesting. I asked him, since the Department of Public Safety is forbidden to enforce the criminal laws except at the request of and under the direction of local law enforcement, are you a certified peace officer in the state of Texas? He said, yes, I am. Do you enforce the traffic code? No, I do not. Do you carry a loaded pistol? Yes, I do. So by that, I take it that you are employed as a peace officer as opposed to a police officer. A police officer is defined in the administrative code as a member of the Department of Public Safety that enforces the traffic code. They are employed as police officers, not peace officers. Now, each one of them must be certified as a peace officer, but they are not employed in that capacity. So my question to the ranger, are you employed in the capacity of a peace officer? And he said, yes, I am. So you are authorized to enforce the criminal code? Yes, I am. Then under Article 2.13 Code of Criminal Procedure, you have a specific duty as a peace officer. So I'm going to send you a verified criminal affidavit against our local district judge, and I'm going to expect you to act in accordance with your duty under Article 2.13, 2.13, 14.03, 14.06. Well, Mr. Kelton, I don't know what that is. Well, you might want to read it. And he said, well, I won't be able to do anything with it. I said, well, I need to send it to you. You need to follow protocol. And then that gives me a claim I can make so that I can get the protocol adjusted so that it is in para materia with statute. So that's my next step, is to send a criminal complaint against my local district judge for first-degree felony aggravated assault. He had me accosted by a bunch of bailiffs prominently displaying deadly weapons in order to prevent me from challenging the grand jury panel. So that ought to be an interesting issue. And then when he refuses to act on it, then I'll file with the local grand jury a criminal complaint against the Texas Ranger, accusing him of violating his duty under Article 2.13. And then I'll sue the Texas Rangers for obstruction of justice. See if we can't get an answer on whether or not a Texas Ranger can act in his own volition and not just be a puppet for the prosecutor. So that's the story on the Texas Rangers. Now, we do have someone in a family case in Tarrant County who filed a complaint with the Texas Ranger, and the Texas Ranger sent a request to the prosecuting attorney, Sharon Wilson, for authorization to investigate this public official. The district attorney denied them authority to investigate, so they refused to. So in that case, I will be filing an information request asking for a copy of the letter or communication sent to the district attorney and a copy of the return email from the district attorney. So in that case, once I get them, then I can file charges in that case. So maybe we can get something sorted out here and get the Texas Rangers in a position to where they're actually an enforcement agency. So since they're still doing a little song and dance with their new statutes, their authority just passed in September of last year. And they were required to put together a set of protocols. And their set of protocols they put together essentially rendered them impotent. So they can't do anything unless the prosecutor tells them they can. And the prosecutor can't investigate. The prosecutor is required to give the complaint to the grand jury. So it'll take a little researching to figure out how to handle this. If the Texas Ranger gave notice to the district attorney that a public official has violated law relating to his office and gave it to him in the form of a request for authorization to investigate it, the district attorney has no discretion. They must give the complaint to the grand jury. So I'm suspecting here that the district attorney didn't. My conundrum is I do not want to go after the Tarrant County District Attorney. We've got kind of a rapport here where at least a mutual respect, and I don't want to sting her if I can avoid it, but it looks like I'm going to have to. I hate the idea of it. Maybe she won't take it personal, but I'm going to have to go after her over this just to get the law concerning Texas Rangers clearly defined by the case law. And this is a case that both parties will have some interest in, so I may actually get a good ruling on it. So my suggestion to you, Scott, is we prepare a complaint against the foreman of the grand jury and give that to the Texas Rangers and see what they do with it. And I'll prepare mine. I've got a foreman and I'll be charging with the same thing. I'll file mine and we'll see what they do with it. As a matter of fact, I may have 3 or 4 other people I can get to file in the interim. Maybe we can get several of these at once.
Well, I think it would be a good idea. I mean, I hope there's a ranger out there listening because I'm born and raised in Dallas, Texas. We always knew the Rangers were the most upstanding group of the law out there. I mean, everybody knew you don't mess with a ranger. It's one riot, one ranger. And these guys are supposed to have the utmost power in the state of Texas. And when we got these prosecutors that are violating the law, they need to be jailed too by the Rangers.
Absolutely. Hang on. We're about to go to break. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. During the break, go check out our sponsors. Help us support this network. We'll be right back.
Hey, wipe that grin off your face. States across the U.S. are officially forbidding people from smiling when they get their driver's license photos taken. I'm Dr. Catherine Albrecht, back to tell you why the long faces at the DMV. Next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
If you're applying for a driver's license in a growing number of U.S. states, don't even think about smiling. A big grin in your photo is now considered illegal. That's because smiling defeats the software they use to map and measure people's features for facial recognition. Officials say they're preventing identity theft by comparing new license photos with existing ones. But of course, once they've got your scowling mug in their database, they can use it to track you. All police need to ID you in a public place is to snap your picture on the street and compare it against what's on file. How long does that take? The answer, 1 second. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Our Radio, and we're talking to Scott in Texas. So, we file a complaint against the foreman, and I'd like to test out the Rangers, but I've got a better one to test out the Rangers with. Here we got a good test of the grand jury, because the foreman claimed a jurisdictional restriction when no jurisdictional restriction exists. So we go back we charge this foreman with, we file with another foreman against this foreman. That should be interesting.
Oh, yeah.
And see, and I'll do the brief in support of this, as there is no case law on this issue whatsoever. And there is nothing in law anywhere restricting a grand jury to a venue. So the grand jury foreman claimed the authority to refuse to act in accordance with 20.09. I want to see that authority. Back to Constitution, and back to the difference between the servant and the master. Master can do anything he wants to. The servant may only do what he's specifically authorized to do. And I see no authorization to refuse to examine into a criminal accusation of a crime that occurred in the state of Texas. And that's my story, and I'm sticking to it.
Agreed.
Okay. Do you have anything else for us, Mark? Scott?
No, sir. I will let you go so you can get somebody else. So I will talk to you Monday.
Okay. Thank you, Scott. Okay, now we're going to go to Sonny in Georgia. Hello, Sonny.
Hello, Randy.
Howdy. What do you have for us today?
Well, I wanted to get your opinion on. Well, first, I filed a rescission of the mortgage before the foreclosure sale, which they went ahead with. They are now sending me a cash for keys type offer, which now I anticipate they're going to probably try an eviction in a week or two. That would just be my guess. And so my question to you, as far as whether your opinion would be on what would be the best chance to get an injunction to stop this, either with a quiet title based on the rescission on the...
okay, hold on. Did the bank purchase the property back?
Yes, they did.
Oh, that's a good thing. I had one of the first cases I helped somebody with. He came to me 2 days from an eviction hearing. Mm-hmm. 7 years later, he had the case won and screwed up on a procedural grounds and lost it. But that was 7 years later. Okay, so point is you're not in dire jeopardy yet. And back to what to do. Quiet title, yes. Has there been filed a trustee's deed?
I don't know.
Check and see before you file, and file against the trustee's deed, and only name the trustee.
That would be a quiet title against the trustee's deed?
Yeah, you only notice the trustee, but a quiet title action is not really a suit against someone. You merely notice the trustee as an interested party. But that's the only one you notice. As far as you're concerned, that's the only interested party. It was the trustee who sold the property and filed the trustee's deed in the public record. So that's the one you name in the suit. If they think somebody else is an interested party, let them cross-complain against the third party and bring them in. But you don't know anything about a third party. Does that make sense?
Yes. If they haven't filed a trustee deed, then would I just file it against the servicer or the?
Well, then you might file criminal charges against whoever's. Yeah, you need to wait until. Yeah, okay, if they haven't filed a trustee's deed, do you have any information to indicate that there was actually a sale other than the fact that somebody told you that? Do you have it in writing?
I don't think I have it in writing.
Okay, here we're talking about the difference between the common civil arena and the legal arena. In law, you don't have it unless you have it in writing. All the rest is hearsay. So right now, somebody told you that it was sold at auction, and they're offering you to give you a few bucks for the keys to the property, but you don't know if they own it or not. So you might want to ask them for a deed to the property. If it hasn't been filed, then ask these people to see the deed or get a copy of the deed. And then once you get the deed, then sue the trustee that's named on the deed.
Okay.
And you do a quiet title against them. That will almost certainly stop them from trying to foreclose or trying to evict. If they file a notice of file an eviction, a petition for an eviction hearing, then you can petition for a restraining order.
Okay.
But when you petition for a restraining order, the court cannot restrain the judge. The court can only restrain the plaintiff. So make sure you ask the court to restrain the plaintiff from pursuing prosecution of eviction until the adjudication of the quiet title action. Does that make sense?
Yes, it does. If they're saying the trustee is Deutsche Bank National Trust Company, from what I have.
Okay. What do you really know? Okay, that was kind of a rhetorical question. What you really know is that somebody signed this document, they put their name on it, and they filed it in the public record. That you know. Now, on this document, they made claims, but you don't know if that's true or not. You only know that somebody's signature is on this document and that somebody filed it in the public record. Mm-hmm. So you want to get the one who filed this and have them prove up the information in the document and then prove up that they had authority to file it. This is what a quiet title is about. The issues in a quiet title is when someone files a document in the public record that affects a claim against real property. In at least in Texas, and it's probably the same in Georgia, they have to have something in the record showing that they have standing to take this action. In Texas, 51.903 or 901C says that any document filed in the public record by someone who does not have a filing in the record showing that they have authority to file a document affecting title is presumed to be fraud. So that gives you the grounds to go back and challenge it. So you challenge whoever filed the document, and then they have to come in to, if they choose to oppose your quiet title action, and prove up their standing to take the action that they took. Hang on, about to go to break. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. I've got a full call board tonight, so if you got a question, make sure you call in quickly so I'll know how many I've got to go through, so I'll try to get there.
Easy.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Sonny in Georgia. I lost my place. Hello, Sonny. Okay.
Yes.
Quiet title. If you need a restraining order, make sure you do it against the plaintiff and not the judge. Quiet. The only one you would name as respondent would be the trustee, because it is the trustee who filed the document. Is there an assignment in the public record to the trustee? I'm sorry, an appointment of the trustee.
Not that I'm aware of.
Oh.
There's only an assignment of the deed to secure debt.
Okay, is the trustee named on the mortgage instrument?
No, I mean not the original.
Okay, make sure you check the record and look for an appointment of substitute trustee.
Okay.
And if there is one, look at the name of whoever appointed the trustee and see if there's a complete chain of holder status from the original lender to this person or to this entity. And then check each document that's been filed and make sure that the entity that filed the document was still in existence when the document was filed. That primarily goes to the original lender. Who was the original lender?
The original lender was Southern Lenders Mortgage, and they went out of business even before this transfer. They went out about 5 years before the assignment.
Okay. Do you have all of the documents that are filed with the county recorder?
I have everything as of, I guess it was about a year ago. I need to go back up there and just check and see what else has been added.
Okay. Send them to me. Let me look at them.
Okay.
But before you do that, I'd like you to do a naming convention for me.
Naming convention, okay.
Yes. Name each file with your last name, a space, the year, dash month, dash day, all in numerals, and then what the document is. If you use that naming convention, when you drop them in a folder, they'll all align themselves in chronological order. The only way you can get it to do that is to put it in that order, year, month, day. Then it'll order by year first, then by month, then by day. And I always want you to put the name on the front, so if I drop the document in the wrong folder, then I recognize it right away and I can move it where it belongs. And I'll look these over and give you kind of a synopsis of what I can find.
Okay, so last name, space, year, month, day, document.
Yes. And also include the HUD-1 settlement statement, note, truth in lending statement.
Okay.
I'll have a look at those, and I can get you some really good claims against these guys.
Okay.
Okay, do that, and this ought to be interesting.
Thank you.
Okay, do you have anything else for us?
Well, one curious point. Deutsche Bank National Trust Company. I've noticed several places online where they are not a registered corporation in any state, and in Georgia, no trust is able to own property because Georgia does not recognize a trust as a legal entity that can hold a property right.
Is this Deutsche Bank trust registered with the federal government?
I am not sure where. I mean, they had an initial filing in the SEC, but then after a couple of years, I mean that they very likely don't even exist anymore. They quit filing after a couple of years.
Okay, well, I will look at that when you send me the documentation. The fact that they weren't filed to do business in Georgia is not necessarily an issue if they were filed with the federal government as a national association. Then they can do business anywhere, and they don't have to file with any state. They don't have to comply with state law. They have to comply with certain state laws. But primarily, they're under the federal government. That's what this was done in Utah. A judge threw Bank of America out of Utah because they weren't registered to do business in Utah, and the court came back 2 days later and said they're a national association, they can do business anywhere, and they don't have to file with anybody. So that's kind of settled. So we'd have to check and see if they were never properly filed to do business like America's wholesale lenders, then anything they touched you can poison.
Where would you check to find out if they were a nationally registered association?
Yeah, dude, you can probably just look all this up on the internet. Okay. Just run their name, and you'll find probably Better Business Bureau. There'll be a lot of things that'll have. I find all my information on the on the internet, and it's relatively simple. Just put their name in and see what you find, and you'll get connections and leads. You'll be able to lead to whatever you need.
Okay. Good deal. Thank you so much.
Okay. Thank you, Sonny. Now we're going to go to Tony in Pennsylvania. Hello, Tony. What do you have for us today?
Hey, Randy. How you doing today?
Doing good.
Can you hear me okay?
Yes, I can.
I was just making sure. Okay, good. Hey, I want to ask you, your air conditioning, you have that taken care of for the next decade?
My air conditioning?
Your air conditioning needs there at the property? You don't
Yeah.
I'm just making a joke. Hey, anyway, I have a question. My lawyer, my case is finally coming to fruition, and we've got a pretrial conference scheduled for next Wednesday. Okay?
Okay.
And my lawyer, I talked to him this morning. We got a phone call from the opposing counsel, the lawyer, and he left me a message and specifically said that they would like to settle and stated word for word that the opposing counsel said my client, the bank, is willing to bend over backwards, which I thought was ironic. But so that happened today, and I discussed with my lawyer what we're going to do next week. But I want to get a couple clarifications. I understand the strong points and the weak points of my case. I think I have a lot of elements in that, but I want to just discuss with you the two elements that might be as questionable as can be, although he thinks it's likely that I would probably win my appeal if it went against us. Everything that he said concerning the weakness or doubts or questions in my case, everything that I said when I refuted it, he agreed 100% with me, and I think that we're heading in the right direction. I think we're just fine. But I just want to...
Okay, hold on. Let me ask some questions.
Yeah, I just want to cover 2 quick points. Go ahead.
How much, what is the fair market value of the property?
Depending on who you talk, I don't know, maybe 2.25 right now, $225,000.
Okay. How much does the bank claim you owe against it?
Well, the original was $171. By the time
no, what's the payoff amount now?
I would guesstimate probably $350, maybe upwards to closer to $400, maybe in that area. Because you know how they get exorbitant with their fees and all.
Okay. Okay. You don't. Do you know how to? Do you know what the amount the bank is claiming is owed against it, absent all of their lawyer fees, and late fees, and all of that?
The original loan was $171, but I'm not even so concerned with that right now. But because my position is that the conditions that I want to not proceed with trial is one, I want the mortgage to be zeroed out, and we can talk about that if you like. But the other thing, I want to ask for legal fees as well as a client title. The one thing that I have a question about concerning that, and that's what I wanted to ask you about, is about the Truth in Lending Act, the rescission notice.
Yes.
Okay. Now, according to this is what I want to ask you about, because some things that he said led me to a couple questions that I would like to ask you concerning that specifically, because that's going to be one of my elements that I'd like to incorporate with when we go next Wednesday.
Okay, hold on. How old is your mortgage?
Well, it's funny you would say that because that's what he was getting at. America's Wholesale Lender, you've heard them before, February 2007.
Okay, you're beyond. Okay, what is your TILA claim?
Well,
let me re-ask the question. Does the TILA claim involve the origination of the note?
I'll tell you what. I sent the rescission notice out 2 days ago. Would you like me?
Now wait. Question. TILA claim. Does the TILA claim go to the origination of the note, or does it go to something after?
It goes to the refinance of the loan, which happened in 2007.
Oh, 2007. Too old. You can't claim the TILA this late. Hang on, Randy Kelton, Louisville Radio. A call-in number, 512-646-1984. We'll be right back. Actually, we'll be back shortly. I'm a little ahead of myself. It's 25 seconds. So good. It's the top of the hour, so it's a good time to go check out our sponsors. And everybody needs jurisdiction area. So do all of that. We'll all be happy and we'll be able to support this network. We'll be right back.
Story for everyone to hear. So how we're not gonna give in to the fear. Yeah, it's a story. I will occupy my father's house till he returns. I will occupy my father's house. He has left me with the story.
Okay, we are back. Randy Kelton, Groove Radio, and we're talking to Tony in Pennsylvania. The reason I was asking you so many questions, Tony, is if you've got the bank willing to deal out, I would seriously consider that, because I've been doing this a long time, and 99% of all of the people who file against the banks lose. Facts don't seem to matter one iota. They lose. So if you have the bank saying they'll bend over backwards to make a deal, because they pretty well know that no matter what happens, you're going to keep them in court till they get old. I would seriously consider a deal. Have you ever sat down and wrote down on a piece of paper what an equitable outcome for you would be?
Yes, I have. Now that's with time, though.
Okay. Go ahead.
Like, in other words, right now, with the Tiller notice, and we'll get into that in a second, I already know what I'm going to ask for next week. I want a quiet title. I want the mortgage zeroed out. And I want the consideration I paid in the mortgage because of Tiller and the legal fees paid. If not, I'm prepared to proceed for trial. My lawyer already knew when they told him before he even talked to me. He says, I already know what he probably wants to do. And furthermore, I already talked to the guy. He's a sharp lawyer. I'm very fortunate to have him. And by the way, I want to thank you because he came through Leslie, okay? And very capable guy. In fact, I will tell you that when so they've already attempted a summary judgment, as you know they would do. And back in September, the judge only took 2 weeks to consider that decision and denied it. And she simply said that it's ordered and decreed that genuine issues of material fact subject to discovery remain and motion is denied. So they still have to answer these questions. He sent in 41 pages of discovery questions, and he let the courts know, and it's in the record, that this is his third attempt to get answers to these questions. And the judge has already acknowledged that there's material fact in what he's brought up.
Okay, hold on. Did the judge give them a time limit to answer these questions?
Well, it's funny you would say that because they never have the time frames, but we do as the citizens. You know how that works.
Yeah, well, generally when a judge says they have to respond to discovery, they generally set a time.
Well, I will tell you this. That decision, what I'm fortunate for, you may not remember this, Randy, but I'll go back, and I told you that the judge that spearheaded the loan modification program in Philadelphia, and we're not going to waste time in talking about what that loan modification really is, but the fact is the judge one of her biggest accolades was that she spearheaded that program. She resigned mysteriously last year, the day after Thanksgiving, after 16 years. You probably don't recall that, but she did. And now I got this judge, very fortunate. She seems to get it a little bit.
Well, it's a good thing if you got a judge that seems to get it.
Well, exactly. So that being said, so where I see the weaknesses in my case, I want to just ask you a couple quick questions regarding that.
Okay.
So Tiller. Now, the reason I believe Tiller exists here, and I did speak with Leslie about this before as well, America's Wholesale Lender, this is a refinance back in 2007. We already know for a fact that I believe they became licensed in 2010. They weren't even.
Wait a minute. America's Wholesale Lenders as a mortgage lending company never existed ever.
Okay.
In 2010, there was a set of corporate papers filed under mortgage wholesale lenders. But this was a bunch of guys that figured out that mortgage wholesale lenders didn't exist, and they went and filed it. And then they had people send in their mortgage documents to these guys, and they were throwing them in the trash.
I believe, yeah.
Mortgage wholesale lenders was never registered. They claimed to be registered in New York, incorporated in New York, and they were never incorporated anywhere.
I thought they might have tried to redo that in 2010, but it was too late. I wasn't sure.
No, these were some other guys that wasn't American Wholesale Lenders who filed corporate papers in that name. And then their parent company, Countrywide. Countrywide sued these guys to try to get the name back.
Yeah.
Okay, American Wholesale Lenders in Florida, a case in Florida, the courts said you were never you never incorporated in New York, and you never filed in the state of California to do business. So you can't do business here. You have to give this man back all the money he gave you. And they said, well, what about the warranty deed? Well, you gave the warranty deed to him. He gets to keep it. So the guy got everything.
So that being said, I just sent 2 days ago the Tiller rescission notice.
Okay.
It names America's Wholesale Lender specifically. If you want, I'll read it to you, just 3 paragraphs. But the bottom line is we're using 15 U.S.C. 1635, Regulation Z 226.23. Okay?
I hope you don't think I have that one memorized.
Well, again, you want me to, it's pretty clear. Want me to read it?
Yeah.
All right, it's real quick. All right. I am writing to you about the above referenced loan transaction, which I entered into with America's Wholesale Lender on or about 2/21/07. Please be advised that I hereby rescind the transaction pursuant to the Federal Truth in Lending Act, 15 U.S.C. 1635, Regulation Z 226.23. I am entitled to rescind the loan because required material disclosures were not provided or were provided incorrectly. If you are the servicer of the loan or another agent of the holder, please forward this notice to the holder of the note and mortgage. Please let me know right away if you are neither the holder nor the servicer. The security interest granted as part of this transaction is void upon the receipt of this letter by operation of law. See 15 U.S.C. 1635, Regulation Z 226.23. Pursuant to the regulation, the holder of the security interest has 20 days after receipt of this notice of rescission to return to me all monies paid and to take action necessary or appropriate to reflect termination of the security interest. Please be advised that if the security interest is not canceled and if all the consideration I paid is not returned to me as required by law, I will have no choice but to seek actual and statutory damages pursuant to 15 U.S.C. 1640A, and then, notify me in writing that it's been canceled, basically.
Okay. When did you file this?
I mailed that myself, certified 2 days ago.
Oh, okay. So they still got.
And by the way, I sent it to the most current servicer, and that's what that language, as you well know, is about.
Yes.
My loan was transferred 7 times, Randy.
Have you had anybody doing an analysis of the documents in the public record?
What, you mean like a forensic examination or something?
Well, I'm not talking about a securities analysis, but just an analysis of the documentation. Who filed what when? And was the filer in existence when they filed? Did the filer have authority to file? There's lots of claims you could have in there.
The only thing that I've done regarding that, Randy, is that I looked up online and I found that the loan was transferred 7 times. And that was new information. I never knew that ever. 7
Okay. I am concerned with the things you're telling me.
Okay.
You're saying that the loan was transferred 7 times.
Yes.
I'm not sure what that means. Let me explain why.
Okay.
Because it's sometimes unclear what was actually transferred. For the most part, there's nothing in public that tells you if the loan was transferred. Most of what you see when you see these assignments is what's actually being transferred are the servicing rights. The note and the security instrument are under there somewhere. Even if the people doing this, they may or may not know who holds them. What they're really transferring is the servicing rights. When all of this stuff about securitization, you understand how that works?
Well, I do. It's funny you mention that because I actually want to bring it up. I understand the process of that.
Okay, hold on. It's real easy to get that in perspective. That's factoring. Nobody ever sold the note. It wasn't the note that was sold. It was the right to collect the income on the note. Just like if you have a company and you have all these accounts receivables. You got a lot of accounts receivables. You don't have any money. So you go to the bank and say, I got all these accounts receivables. Will you buy the receivables from me? And they'll buy them. And then when the payment comes in, it goes to them. That's what securitization is. So the note never really sells to these guys. The right to collect payment, that's what goes into the trusts. And that's why everybody fighting those issues are getting hammered so bad. So the note itself and the deed of trust. Most states have a statute that's similar to 13.001 Texas Property Code. And this is what it says. Any claim against real property not properly acknowledged or proven and filed in the public record is void as to the holder. You have one similar in Pennsylvania. So that is really, really important. Because I don't care who holds what. If you can't show by the public record a complete chain of title in the public record, bringing that title to you, well, you wipe your behind with your claim because you can't bring it to the court. So that's why you really need to look close at what you find in the public record. You won't believe the garbage you find in there. I just found one where Chase Bank filed a notice of lost assignment. And he put in here, we got this secure vault in Louisiana, and I went through the whole thing, and I couldn't find that thing anywhere. 3 days later, he files an assignment to somebody else. Duh! You just said you don't hold it. and then you assigned it. So that was statutory admission that they have no standing. You'll find the most incredible garbage in there. You should look real close at that. But that should be the first thing you do.
Well, I did, when I started this whole, journey, Randy, the first thing I did, I went downtown. I got a copy of every document against my title.
Okay.
So
who is the original? Okay, original lender was American Wholesale Lenders?
Yeah, they're the ones, and then I found out that they turned it over to Countrywide immediately.
Yeah, because Countrywide was the real company.
In addition to American Wholesale Lender.
American Wholesale Lenders was a DBA for Countrywide. And this is where they got into trouble, because Countrywide never actually existed. Hang on, Randy Kelton, Ruleville Radio. Our call-in number, 512-646-1984. Give us a call. We got 3 more segments. We'll try to get to everybody. And go check out our sponsors. We have our fund drive on. We only do it once a year, and we need all the help we can get this year. And we'll be right back.
This is the Logos Radio Network.
Oh, come on.
Okay, we are back. Randy Kelton, Ruleville Radio. And I'm going to shut up now and let you frame your issue. I've been interrupting you this whole time.
Thank you, Randy, because like I said before, last year there was specifically America's Wholesale Lender case in North Jersey that was ruled almost, this is basically identical to my case. In addition to the America's Wholesale Lender, I got the MERS issue as well, and that's the only other question regarding that is the TILA and the MERS. But there was a case last year in North Jersey that was awarded. This guy, I don't know, he had like a $500,000 mortgage, whatever the case was. America's Wholesale Lender, he made like one payment or something. They gave him, they zeroed out his mortgage, quiet titled, and gave him all the monies that he paid back in the loan, which I heard you say, and I think that's the answer to my question, meaning that that was the last element I want to ask for, which is my money's paid on the mortgage back.
Okay, that is a straight-up requirement. And the real issue in Jasinowski, the recent Supreme Court case, was that the bank claimed that the borrower had to tender first. And the Jasinowski case said, no, the bank has to tender first. So the bank has to give you all the money you paid them back first. Then you have to tender the property back to them. Unless what they give you is enough to offset the value of the property. Go ahead.
Yeah, I heard that little twist at the end there.
Yeah, both parties have to tender. You tender to them what they gave you. They tender to you what you gave them.
Did Jasinowski keep that property then?
I don't know what happened in Jasinowski. I didn't hear, I don't know what their equity range was. And it depends on how much equity you have. And it depends on whether you want to keep the property or not.
Yeah, but what I'm asking you, Randy, is are you telling me that with that decision he got, he's supposed to give that property back to that bank?
Absolutely.
Oh, real?
Oh, yeah. He gets all his money back, but he gets back what he gave to the bank. The bank gets back what they gave to you.
But at the same time, I talked to my lawyer about a quiet title. He thinks I have a pretty decent chance to get that.
It won't help you.
Likely that I'll win my case in appeal.
It won't help because you'll still have the note out there.
But the note was signed by a woman who is deposed in 2012 as the never signing a promissory note ever, and that's forgery.
Okay.
And it was notarized by a woman who has an office in California, and I think that's against the law and another count of forgery to even try to notarize a document out of state, correct?
Did you adjudicate those issues?
No. My feeling was to go forth with this case, let the litigation get over with, and start filing charges.
Well, you're likely to get it. Okay, wait a minute. What is your claim at the moment?
That this mortgage is illegal. That America's
No. I'm really wanting something more specific.
Well, I think that I'm entitled to get this mortgage wiped out.
That wasn't my question.
Okay.
What is the claim that you made against the lender? cause of action?
Well, they brought me to court. I didn't make a claim against them. They came to me.
Okay, so what was they sued you for foreclosure?
Yes.
Did you make a counterclaim?
Yeah, exactly, yes.
What was the counterclaim?
That's where the 41 pages, and we put into discovery, 41 pages of discovery. And what my plan has been all along, Randy, I'm in this for the long haul. And the reason I'm in this for the long haul is to create case law for people, to make it easier for them. Because this is about right versus wrong. And so 41 page discovery, my lawyer brought up in the summary judgment that was denied that he's already come to them 2 times earlier with this information. So at this point, when the trial starts, they have got to start answering. I told you the judge has already said that genuine issues of material fact. They've got to start answering my questions. And when they start answering questions, that's evidence. It's going to be fraud and forgery, almost every single thing that they say.
Okay. Wait a minute. Then why are you calling me?
Well, because I wanted to know about the TILA. My lawyer had some questions about that, or he led me to have some questions about that, to where I wanted to find out. You've already answered that for me. And I do recall that the other issue concerning MERS, I've seen some adverse rulings, And by the way, I don't know if I mentioned to you, remember Nancy Becker?
No.
Do you remember her, the Montgomery County Recorder of Deeds?
Oh, yeah, I remember that, yes.
Well, she was, I just found out today, she was voted out of office.
Is that right?
Yeah.
After winning that big a deal, she gets out of office. That is nuts.
Well, I don't know if you know that other lawsuit, she got ruled against, by the way. And coincidentally, you know who ruled against her? Donald Trump's sister.
Well, that's okay. Okay, that's not surprising.
Well, that being said, my question, but I did notice that too. I saw a paralegal talked about that case and others, the one in Dallas, that they went about it the wrong way and the kind of thing. But they also believe, like I'm telling you, that these lawsuits are going to start happening. And even my lawyer, when I talked to him today, mentioned that there are 2 lawsuits on the horizon. One of them is J.P. Morgan Chase.
Okay, but you're not telling me anything. What is lawsuit on the horizon? It's probably 10,000 of those. Something more specific.
Let's start somewhere.
Okay, even in your case, I have no idea what your case is about.
Right, but to answer the one question, the other question was concerning the MERS. These were the weaknesses of what I discussed with them today in order to proceed forward. And the other one was, I think you touched upon it last week, which was that, if they work around the MERS issues and that's questionable, that I can always file a RICO suit for the filing of false documents on my deed, correct?
RICO? Maybe.
Yeah.
There may be a more direct way, and you might. I'm not intimately familiar with Pennsylvania law. I'm somewhat familiar. In Texas, we have a statute that says that any document filed in any public record that is fraudulent is void. Not voidable, but void. I just talked to someone who lost an appeal because they argued that the document was forged and argued for quiet title, but they did not argue that the document was void as a matter of law. And one of the dissenting judge indicated had they made that argument, they'd have won their case because the document was void. They didn't argue it. So if you have reason to believe this document is void, check the code. See if the code says the fraudulent document is void. And if that's the case, do a quiet title action against that document and have it removed from the record.
Okay.
Now you got res judicata. Anyone who bases their standing on that document just got booted out the door.
Okay.
Okay. Any other questions?
No, I think that covers it, Randy. I do appreciate that. And oh, by the way, you were talking for a moment about the gold and such. If I'm not mistaken, just one question: wasn't gold in the 1929 Depression? Didn't they the government require that people turn their gold in, the hard assets that you were referring to?
Yes.
So
gold has been required to be turned in. Silver never has.
Yeah, so if you get the hard assets like your guy was talking about, they might want them.
Yeah, I don't advocate gold. Other hard assets, copper is a great one. It's a little bulky. Lead is a great one. It's really bulky, but you don't have to worry about anybody stealing it. That's why I said something hard.
I got you.
Yeah, there's other things that are hard other than gold. Gold is a good way to maintain wealth, not a good way to gain it. You look for a commodity that's going to increase in value. Okay, we're about to go to break. And where we at? Mark in Texas. We'll pick you up on the other side. Randy Kelton, Real Law Radio. We'll be right back.
Coke and Pepsi aren't the healthiest of drinks, but they recently got a tiny bit better by changing a common ingredient consumer watchdogs say might cause cancer. I'm Dr. Catherine Albrecht, and I'll tell you what that controversial chemical is next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
For decades, Coke and Pepsi have insisted their soft drinks are completely safe. Well, they haven't changed their story, but they are changing the caramel coloring that gives colas that rich brown hue because it may cause cancer. It's called 4-methylamidazole, and authorities in California say it's a carcinogen after high doses cause tumors in animals. Turns out that caramel coloring is made with ammonia and other chemicals. The companies say you'd have to drink 3,000 cans a day to match the study's doses, but they're changing their colorings anyway, nationwide. Now, if they just deal with all that genetically modified corn syrup. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Getting about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
I see two. You ever done I see tools of ingenuity. Use against the workers of iniquity.
Okay, we are back. Randy Kelton, Real Law Radio. And Mark, I was going to take you, but I've got someone in a felony case that's been denied counsel through the whole case. This is a question of liberty, so if you don't mind, Mark, I'm going to take William in Idaho first. Hello, William.
Hi, Randy.
Howdy. What do you have for us?
Okay, well, I've been trying to get a hold of you. I've been through a long drag-out court process for this. I think this is from, 2014 in June or July. And,
okay. What's the nature of the case?
Okay, it's a felony eluding on a motorcycle. Is what the...
Wait a minute. I'm having a little hold on. Move the mic a little bit away from your mouth. I'm having a little trouble understanding you.
Okay, how's that?
That's better.
Is that better? Okay. So this is felony eluding. I sent your Randy...
wait a minute. Start again. I didn't hear the first part. It's a felony what?
Eluding, like eluding a police officer.
Wait a minute. I couldn't understand that.
I'm going to change. How's this? Is it any different?
Your voice sounds a little higher. Maybe you can understand it better. A felony eluding?
Eluding, like running from a police officer.
Okay. What occurred?
Okay. So the basic issue I wanted to talk to you about, because this is we could talk for days on all the different aspects and all the different things that they didn't do or did do.
Okay, okay.
Specifically,
okay, get to the issue you want. So I didn't want to have to go through the whole thing.
Yeah, exactly. So specifically, I've got a situation where I'm asking for counsel the entire way through. It's well documented that I'm asking for counsel all the way through. And
okay. Why are you absent? Why are you absent counsel?
Why? Okay, so at first they were denying it. From arrest, they were denying me for the first 30 days even getting into the law library while I was in custody.
Wait a minute. Getting into the law library doesn't go to... Did you waive your right to counsel?
No, I didn't.
At your first hearing, when they first brought you before a magistrate, did you ask for counsel?
Counsel. Yes, assistance of counsel.
And did they not give you counsel?
No.
And they've never given you counsel?
So
what they did is eventually they gave me counsel and then took it away twice.
Okay. Did counsel request to be removed? Did he request to withdraw, or did the court remove counsel?
Okay, the problem is there was a private attorney that got on the case and made an appearance that wasn't hired.
Did you know this attorney?
I went with my father and met with about 5 different attorneys to get second opinions on the counsel that was provided not doing their job. And one of them made an appearance without being hired on the case. And then that automatically stops the counsel that you have from being able to talk to you.
Okay. Did you file a removal of counsel?
The guy that got on, what ended up happening is we had a hearing to remove the attorney that wasn't supposed to be there off the case. They did that, but then they didn't they just refused to hear.
Did you file a motion for court-appointed counsel?
Yes.
And did they hear the motion for court-appointed counsel?
Every way along the time, I'm asking for counsel. And then when they say
did you file a request for court-appointed counsel?
Court-appointed counsel, a declaration of indigency.
Okay. Did the court rule on that?
Well, so they gave counsel initially, yes.
You're confusing me.
In a way,
let's stay in the timeline. Did you just jump back to the beginning of the case?
This is okay. So
wait a minute. Hold on. We're having a problem here. You initially had counsel, appointed counsel. A lawyer appeared that shouldn't have. They took away your court-appointed counsel. You filed to have this counsel that made the appearance removed. You filed again for court-appointed counsel. Did they appoint you counsel based on that second filing?
No. They said that because the counsel that was that made the appearance, they kicked the other one off, because in his statement at the hearing, he had said that there was a breakdown in the attorney-client relationship, as in there was never a relationship, and he also said that money wasn't an issue. Well, money wasn't an issue because he was never hired. So the court took that as that they didn't have to provide any counsel.
Did you file an appeal?
For the case?
Yeah, an interlocutory appeal.
No, not an interlocutory appeal. I have filed so that we've already had a trial.
Okay, did you petition the Court of Appeals for writ of mandamus?
No, I haven't.
Okay, this is your remedy. Eventually, they'll walk you through this whole case, and you'll appeal the case for lack of counsel, and the whole thing will get overturned. What they're trying to do is wear you down.
Well, they're trying to stick me in jail, and then maybe.
I understand that. They're trying to wear you down so you don't fight them anymore.
Yes.
That's what these guys do. Have you filed judicial conduct complaints against the judge?
Have not. I've been working on that.
Bar grievances against the prosecutor?
Prosecutor, the attorney that I've been working on the ones, there's probably half a dozen at least different.
File grievances on every one of them?
Mm-hmm. For multiple things.
Okay. So. Understand, they're not going to cut you any slack.
Yeah, it gets so fast.
They're going to nail you as hard as they can, whatever they can get away with. So if you're going to get any leverage, you're going to have to start hammering them. And file a judicial conduct. Working on one, you should be able to file one in 5 minutes. You understand, if you file a judicial conduct complaint against this judge, your state commission on judicial conduct is going to get that complaint and they're going to throw it in the trash.
Mm-hmm.
So it don't matter what you put in it; they're going to throw it in the trash.
Mm-hmm.
But that's going to affect his bond rating.
Mm-hmm. Okay.
That's where it hurts him. So you just file it. Same thing with lawyers. You file a bar grievance against them, the bar is going to throw it in the trash no matter what you file. State bar there is just there to do song and dance and seltzer down your pants.
Yeah.
But when you file against the lawyer, they're going to raise your insurance rates.
Mm-hmm.
So start doing that first, and then petition the Court of Appeals for writ of mandamus, asking them to order the court to appoint you counsel because you do not waive counsel and you can't afford counsel. They cannot try you in a felony case without counsel, period, unless you have waived counsel in court with temporary counsel present after full disclosure, free of coercion. No way they get by it. You have to do a mandamus.
Okay.
Okay. About to go to break.
I'll let you go break.
Okay, about to go to break. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Rule of Law Radio, and this is our last segment. And sorry to keep you so long, Mark. I didn't mean to put you off, but I'm concerned about this guy with liberty's always more important to me. Okay, what do you have for us, Mark? Mark, did I put you to sleep? It looks like we lost Mark. Okay, now I'm going to Larry in Arizona. Hello, Larry. Hello, Larry. Looks like we are having a problem with our call board. Let me see if I can go back to William. He's still on the board. William, are you still there?
Yeah, I'm still here.
Well, I guess our call board's not down, but nothing else is working. Okay, we're having a little technical difficulty. So, you cannot be convicted of a felony without counsel unless you have knowingly, intentionally, in writing, waived your right to counsel. So what they're doing is trying to wear you down. They make you come to court and then come back and come back and come back and come back until you take a deal. And you were charged with eluding. Now that's eluding arrest, correct?
Yeah, you there?
So what happened to the charge for which they intended to arrest you?
Can you hear me?
Yes. Okay. What happened to the charge that they were going to arrest you for on the first place?
Oh, there was 6 or 7 different other tickets. There was like a license plate being...
Oh, okay. So they were adjudicated somewhere else. Okay. What I was getting to there was there had to be probable cause.
Yes.
Yeah. You can't elude arrest unless they had a right to arrest. Okay. So the felony eluding, I'm going to take it's felony eluding? That's pretty serious. Okay.
It's 30 miles an hour over the speed limit. Turns it into a felony, I guess.
Oh, okay. Have they offered you a deal?
I don't know. I don't think so.
Okay. You need counsel.
That's the whole point is this is the 3rd time I've been arrested in this county. I already beat the last 2 charges in this county and had lots of issues with the prosecutor. And this is just, this is just one of, okay, let me back up slightly. So in the last 3 years, I've had 15 different arrests on BS charges, and I've beat all of them except for this eluding charge, which they were able to win because they denied me pretty much any access to.
Have you filed criminal charges against the prosecutor and the judge?
I have not.
Oh, wait, I got an idea. This is a due process.
There's been 3 cases at a time going for the last 3 years.
Wait a minute, say that again. If I'm talking and you're talking, it shows your voice down below mine. We have a suppressor on here, so I missed what you said.
Oh, yeah. Okay. So I've been a little overwhelmed because there's always 3 different charges. For the last 3 years, I've had 3 different charges going at the same time. So in the last 3 years, there's been 15 at least different arrests, and I've won all the cases except for this one.
This sounds like a great case for a federal due process suit.
Oh, there's a lot of them, and there's a lot. I mean,
okay, you might look at 42 U.S. Code 1983.
Yes, but I need a lawyer.
No, you need to do your homework first. If you get a lawyer and you expect a lawyer to take care of your rights, you don't understand how it works.
Mm-hmm.
Your lawyer is in business. I know you may have watched Perry Mason on TV and think that your lawyer just goes out there and fights like crazy for your benefit. That ain't how it works. Your lawyer's in business, and your lawyer is absolutely beholden to the judge. The judge can end his career on a whim. So lawyers are terrified of judges, and they're reluctant to do anything that the judge is not going to like. You will not win your case simply because you have the law and the facts on your side. You'll only win your case if you have the politics on your side. That may not be right, but that's how it works where we live. And in this case, you need a lawyer, but you need to know what your lawyer should be doing so that you can kick your lawyer in his professional teeth when he doesn't do it. And then when you start kicking your lawyer, then your lawyer is going to go to the judge and the prosecutor and say, hey, guys, I got this client and he is busting my chops. You need to help me out here. Now, I bring you all these clients and I get them to make a deal and we all get your docket cleared. Now you owe me one. Everything's political. If you need to get some politics on your side, that's why I mentioned the bar grievances and judicial conduct complaints. That hurts them. They're never going to tell you it hurts them, but it hurts them.
I've been listening to you for the last, 5 years. And the only reason I'm not in jail for 20 years to life or whatever it is for all the crap they've made up is because I've been able to I guess, push the politics and
okay.
It's just that when you get 3 cases at a time running, it's hard to keep up.
I understand. It's overwhelming. If you handle 3 at once, that's remarkable. Because it is overwhelming. And it's hard for people who haven't been under this pressure to realize how difficult it is. When Cherokee County was coming after me, just to write a pleading for me was major, major stress. I had to struggle. I didn't want to touch it. It was so stressful. I didn't want to look at it, but I had to. So, yeah, that is very difficult.
So I have to clarify when I'm asking for counsel, I'm very specific with asking for counsel. And I'm asking for counsel, assistance of counsel. But I want to drive, pretty much. Or, pretty much, I guess let's go, there's as far as Idaho is concerned, or I guess should be anywhere, there's full representation, there's standby or assistance and counsel where they're not in the first chair.
Yeah.
And there's full, the pro se. So that second one is the one where you go, okay, I'm the third party beneficiary of that relationship, right? And I want to drive, but I still get assistance of counsel.
Okay. Well, when your liberty is at stake, that's a big concern.
Yes.
You're better off with counsel because your counsel can negotiate with the other parties.
Yes.
You need to understand the politics. Going to court is like playing four-sided chess. If you listen to the show a lot, I'm sure you've heard this before.
Mm-hmm.
It's like a four-sided chessboard. You got your lawyer over here, your right, opposing counsel to your left, the judge across from you. All 3 of those guys have relationships. You're the odd man out. You only got a relationship with your lawyer. He has a relationship with everybody. So you need a lawyer that you can position such that he goes to these other 2 that he has a relationship with and uses that relationship to get them off of you so he can get you off of him.
Yes.
And when they appointed me the lawyer, first thing I told him was that he was going to file a motion to be removed from the case. And I said, and the judge is going to, and when you file the motion to be removed, I'm going to object to the motion, tell the judge that he's my counsel. He's my counsel of choice, and he's under contract. And the lawyer said, well, I'm not under contract with you. I'm under contract with the state. I said, yes, you are. But I'm the intended third-party beneficiary, and I have standing, and the judge is going to remove you. And he said, yes, he will. He said, then I get to sue the judge for interfering with the private contract. And the lawyer sat back and looked at me, and he's thinking, this guy's going to get me disbarred. They threw out my case to protect my lawyer from me.
Yeah. So, been there.
Okay, so I suggest you need counsel, even if you have to hire counsel. This is your liberty.
That's not possible because this has been, when you have this job for 3 years, just fully time fighting counsel.
Okay. Then what you need to do is go online, do some research, file a petition for writ of mandamus, and ask the higher court, the appeals court, to order this court to have you appoint your counsel.
Okay.
That will probably get that done.
Okay, I understand that, but this has been once they've already crossed the line, egregiously. Do you mind if I talk to you after?
No, we are. Yeah, send me an email at Randy at Rule of Law Radio. Okay, we are out of time. This is Randy Kelton, Rule of Law Radio. Our call-in number. Forget the call-in number. Thank you all for listening. We'll be back Thursday on our regular Thursday show. And make sure you go check out our sponsors and help us support this radio network. If we have been of any value to you, we would, once a year, we ask for some of it back so we can keep this going.